word common means similar. In one word, we can define common law as judgment law. In a case where there is a new fact and circumstances comes before the judge, the court and jury takes into account of the customs, situation and other related matter in passing a judgment. In future, in the similar circumstances, the judge and jury rely on the precedent, that is, the judgment passed earlier. So, the common law is also known as case law. Common law had impact many centuries back, but in 1066, after the Norman conquest, during the period of William the Great of England, it was institutionalized. It was practiced in the King's Court of England. The modern times, the common law is used to fill the gaps in the statutory law as it acts as a bridge. Broadly, the common law can be divided or classified in two halves. One, general common law and two, interstitial common law. But Blackstone has gone further and divided and simplified the common law under four heads. 1. Right of persons. 2. Rights of things. 3. Public wrongs. And 4. Private wrongs. One of the drawbacks of the common law system was rigid and inflexible, and the only remedy available under the common law courts was damages, but was not sufficient for all the cases, and numerous petitions were submitted before the king. So in England, the Court of Equity, that is the Court of Chancery, came into existence to meet the laches or deficiencies existed in the common law system. If there is a conflict between the common law and the law of equity, the latter will prevail, as it was well settled in the Earl of Oxford case. The common law and the law of equity can run together in courts after the passing of the Judicature Act of 1873 to 1875. Though the common law originated in England and spread in the countries where British colonies existed, today the common law and civil law system both administered in England and US.